of course, if you didn't do this, I'm hopeful that you didn't do this and they arrested the wrong person. But if they do have the right person, it's really important that you maintain your behavior level and give your attorney as much as possible to work with. Certainly don't do anything that helps the district attorney prosecute you. Okay? All right. All right. Thank you, Saban.
Can we say something, Your Honor?
What did you want to say?
I mean, we're not arguing his case. Ain't this like a detention hearing to see if he can come home and go to court from home? I mean,
yes.
He's been doing everything he's supposed to do in there. It seems like y'all just keep telling him the same thing over and over just to detain him. You done already told him what you just said the first time he went to court. It's like y'all ain't giving him no reason to keep doing good. And every time he come to court and he's doing good, he just keep detaining him.
Would you
See what I'm
prefer?
saying?
Yeah. Would you prefer that I just never tell your kid what the potential consequences are?
No, I'm not saying that. I'm not saying that.
I give you the courtesy of letting you talk without interrupting you. I don't know why you're not going to give me the same courtesy. So would you rather me not even tell your son, or I don't even think you're the dad or stepson or whatever, if what the potential consequences are? I think it's really important for him to know that he is potentially looking at life in prison with parole for this offense and how serious this offense is. So you're telling me I'm just repeating myself. Should I not make sure he knows this?
No, I'm not saying that. That's not what I'm saying.
Okay.
I was just asking, if my son, he's been doing what he's supposed to do. I mean, why couldn't he come home and go to court from home?
On house arrest.
So the reason why, sir, is because when you say your son's doing what he's supposed to do, you understand that he actually stole a firearm, right? And he was placed on felony probation. I would not say he was doing what he was supposed to be doing. And while he's on felony probation, he is now named as a witness in a robbery shooting where somebody was shot. Okay, I don't think that's where he was doing what he was supposed to do. And while he was robbing somebody, he was trying to rob somebody of THC, a felony drug possession, which again, I don't think he was doing what he was supposed to be doing. And then when he came in, he's of course positive for THC. So while he's on probation, he's smoking weed, has a gun, robbing people. Do you still think he's doing what he's supposed to be doing?
Oh, this is not going well for him, is it? He thought he was gonna straighten Judge Kim out. Oh, good Lord. I have to blame Evan for this. I blamed Evan for the first clip earlier. It wasn't Evan, it was Jalapeno. But Evan was working on this, and it's fantastic. This goofball thinks he's going to knock Judge Kim off center. It doesn't work. In fact, it gets worse. Let's carry on, shall we?
I'm just saying, ain't people innocent until proven guilty? Who's to say he did it?
He's guilty of felony theft of a firearm. He admitted his guilt, and he's smoking.
He admitted it. We're past conviction here, dummy. We are past conviction. The argument is so bad. I mean, right, starting with just philosophically, the grammar, logically, any way you slice this argument, it sucks.
Weed while he's on probation.
He was, it's okay, Your Honor. I'm not trying to get you upset or anything. I'm just trying to talk for my son. That's it.
Yeah, I'm not upset. But you understand when you say he's doing what he's supposed to be doing while he's on felony probation, while he has a gun, while he's robbing people, allegedly, and while he's smoking weed, definitively, you're telling me he's doing what he's supposed to be doing. Now, the concern for me is if he wants probation, I have to approve this, at which point the things that you're saying does not give me much confidence that the home is a good environment for him. Like he was smoking weed while he's on probation while living in your house.
He was already dirty, Your Honor, before they put him on.
All right, I can tell you, I'm messaging back and forth with Evan because he's like, I got this clip I'm working on. There's an attorney with the turkey. And he's like, I got to talk to this guy. He's obsessed with the attorney with the turkey now. I think it'll happen before it's over. But I anticipate future content with turkey attorney.
Probation, but it's okay. I don't want to go back and forth with you. You know, I was just trying to speak for my son, trying to get him home. That's all.
So
Yeah, you don't want to go back and forth with Judge Kim because he's wiping the floor with you. But yet you're still so stupid, you do it anyway.
He was placed on probation when?
I don't know the exact date.
Your Honor, he was placed on probation on November 6, 2025.
Right. So he was smoking weed. He had 3 months to pee clean, and he didn't. So, sir, I mean, what did you and your wife do to keep him from smoking weed while he's on felony probation?
He wasn't on probation no 3 months.
He only been dropped one time, and then he only been dropped twice total since he been on.
Dropped. What does drop mean?
Like urine testing. I'm sorry.
So he was placed on probation.
You know, when you use a lot of marijuana, it takes a while to get out your system. Everybody.
Are you a physician, sir?
I mean, no, but I know. I mean,
how long does it take for marijuana to get out of your system?
I know it takes longer than what they say it do.
Really?
I know that.
How do you know that? What peer-reviewed
Because
study
I'm
have you read?
46 years old. I've been living a long time, Your Honor. Like I said, I'm not trying to argue.
I think Judge Kim is skeptical of this guy's medical credentials. It's just a feeling I have. I'm not sure.
Man, if you're going to detain him, you're going to detain him. I'm just like y'all just keep telling him.
Hold on, sir. I'm not man. I'm not dude. Right? I'm judge.
Okay, Your Honor. I'm sorry. I'm not trying. That's what I'm saying. I'm not trying to. I was just trying to speak for my son. That's all. We can count. We can. It can be over with now. I'm sorry. I'm just trying to speak for my son. That's it.
It's funny, D-Man. I use that exact analogy. Great minds think alike. I use that exact analogy in a chat with Evan.
Sir,
Man.
clearly you're enabling your son. You're justifying his marijuana.
I'm not enabling my son. Do you hear what he's saying?
You're telling me that for 3 months, marijuana doesn't get out of his system, that his marijuana use was before he went on probation. One, physiologically, that's not possible. All right. Second,
Yes.
why was he smoking marijuana even before he went on probation? Like, you're saying that's okay.
I'm not saying that's okay, but it's a different day. You know, it's not like when we was growing up. These kids these days, it's you know it's a different day. It's different. Everything is different now with these kids. There's only so much we can do.
I guarantee that I can give my son a drug test and he will not test positive for marijuana.
Boom.
All right. Okay, Your Honor.
So
I don't want to hold the court up.
When you say there's nothing,
So there's that. And the reason why he can say that, it's not that his son wouldn't do it. It's that his son knows that he would whoop his ass if he did it. It's not because he's a judge. None of those things. It's because it's not tolerated in his household. Period. End of statement.
I can do.
Saying anything.
When you say there's nothing we can do to keep these kids from smoking marijuana, you know, the majority of kids do not smoke marijuana, right? The majority of kids in this detention hearing do, but the majority of kids out there don't. You seem to be justifying and enabling your son saying, hey, I can't stop it from happening, so I'm just going to let it happen. That is actually what enabling is.
Okay, Your Honor. Okay, you got it.
So,
Thank you.
all right. So, Savan, we'll see you in 10 days.
Thank you, Your Honor.
Can I ask you a question?
Yes, Judge.
Why would you do this?
Good morning, Mr. Riddell. How are you?
Good morning. How are you?
Doing well. I have, I think, Edward.
Okay. This, I don't want to give much away. This is Zach's fault. He sent it to me. Landlords Unite, all that good stuff. He sends me this. He gives me a description. His descriptions are usually pretty good. I force myself to not watch it because I want to see it live with you guys. It sounds like a train wreck. We'll see.
Altman is connected here. Let's bring him in before we get too far.
My client is out there someplace in the ether as well.
What was his name?
Jay Patel.
Okay. Yep, I see him as well. Mr. Altman. And then Mr. Patel's in here now, I believe. Mr. Altman, are you there? I need you to unmute, sir. All right, we're going to give him a second here to figure that out. I'm going to let in these other individuals.
I'm here, sir.
All right, one moment, Mr. Altman.
Good morning.
Morning. Okay. For the Altman Seville, it's 2503130 LT Seville Motel versus Alex Freeman and Edward Altman. Mr. Riddell, your name, please, for the record.
My name is Neil Riddell, and I'm appearing on behalf of the landlord plaintiff in this case, Seville Motel.
All right. And Mr. Altman, your name, please.
Edward Altman.
And do you have the other named defendant here with you?
Actually, he's in the hospital. We've had some difficulties in the past couple of weeks.
Okay. Mr. Patel is here, I see. So Mr. Riddell and Mr. Altman, would you like a moment in a breakout room? I know we had some unresolved issues we need to get to here in a moment, but is there any benefit with a breakout room discussion before we get to that?
Judge Neil Riddell on behalf of Seville. I don't think so. The purpose for the adjournment was for the defendants to secure an attorney, and apparently they don't have an attorney here today. And I move for judgment on this matter right now. This is a termination case. The proper procedures were complied with, as shown in the.
Hell yes. I don't want to talk to two unrepresented defendants when I've got this case locked and loaded. There's no reason to talk to these people and hear them whine and say irrelevant crap. Let's do it.
Court's file on this matter, and there's no tenable defense that's being raised or could be raised by either of the defendants, one of whom is not here.
Mr. Altman?
Yes.
What is your position here this morning?
Sir, I still have not been able to find an attorney. I've reached out to several and none have taken my case. We would like to.
Yeah, because you have no money or no case. I haven't seen this yet, but that's my overwhelming guess as soon as I hear that.
Offer to the court to be gone out of the motel by the second week of March.
All right.
Judge, from
Yes.
the viewpoint of Seville, that would not be acceptable. They have been living on that property rent-free since early in November. From the date of the service of the notice of termination, they've stayed there accruing accruing motel charges of $2,640. They're unpaid 3 weeks prior to that, and the total that they owe for their occupancy of the motel property is $3,360. Now, if they want to post, pay the arrearage and post a cash bond with the court for the amount of up to the first week of March, maybe we could talk about that. I don't know if they're capable of doing that, but we're at a point where, we're entitled. We follow the procedures. We were entitled to possession of our property, and they've had plenty of time to work out alternate arrangements. My understanding is that they're waiting for some negotiation so they can get financing, so they can go forward to secure another place to live. Fine, Judge, I understand that, and human to human, I can feel the sense of compassion for their position, but we've given the notice of termination. We're entitled to recovery of our property, and as I say, as of today, there is owed.
I have empathy for the defendants, but GTFO.
$3,360, which we haven't sought to recover because it's a termination case. could have been anything other than a
And he's
termination case, we would have included that as part of the claim.
All right. Mr. Altman, you've heard Mr. Riddell's position. Any response?
Yes, like I said before, we are trying to move out of the location. However, it is not for lack of payment. We've offered to pay the past due, and it was been refused.
Okay, so here's the thing. We got a full courtroom here today. It sounds like there's a few things that you guys could potentially work out here this morning. I'm going to put everybody into a breakout room. It doesn't need to be a long conversation. If there is no meeting of the minds, you guys can come back in here. We'll recall the case shortly. But I will say typically when it's left in my hands, nobody's happy. So maybe you can reach some kind of compromise where everybody can leave here with a feeling of that you've worked something out. So I'll put you guys together briefly, work on some other cases here, and we'll recall you, okay?
Thank you, Judge.
Yep.
Your Honor,
Yes, Mr. Altman.
I did want to ask, can I be evicted for being gay? Because I believe that is the groundwork of this whole situation.
Well, Mr. Altman.
Short answer, yes. Okay, not really.
Altman, the answer to that question is decidedly no. But we can discuss if there's some evidence that you want the court to consider as whether or not that's the driving force here. It also sounds like there's this pretty significant arrearage, which I'm sure is going to be the petition of the plaintiff in this case, that you haven't paid the rent. And also the reason for the action is just simply a termination of tenancy. I don't believe there's a lease in place, if I recall correctly, Mr. Riddell. This is essentially moving on it's at a motel and a kind of a cycle of renewal. Is that correct?
Weekly occupancy, Judge.
Weekly occupancy. So it's a short interest you have in the property, Mr. Altman, but that's something we can talk about here once we recall the case. I understand.
Your Honor, we do have Your Honor, we do have a lease. Anything past 30 days is considered a lease, even if it's a motel. I do know that much.
All right, Mr.
So
Altman, again, I have a full courtroom, and if this is going to take some time, I'm happy to give you guys the time. It's just I need to clear out some other cases first. So let's take a moment in the breakout room, and then I'll recall the case shortly. Okay?
Thank you, Judge.
Your Honor, I'm just adjourning ours.
Okay. All right. I'm going to recall the Altman matter then. This is 25-03130 LT, Seville versus Alex Freeman and Edward Altman. Mr. Riddell, your name again for the record. You're muted, Mr. Riddell.
Neil Riddell, apparently on behalf of Seville.
Thank you. Mr. Altman, your name?
Your Honor is Edward and Alex Altman, not Alex Freeman. It's Alex and Edward Altman.
All right. I apologize. It's listed as Freeman, so if you want that to get changed, you could always file a motion, but it's listed as Alex Freeman, and that's why I keep referring it to that way. I also have Mr. Patel, who's the property manager or property owner here and connected as well. Mr. Riddell and Mr. Edward Altman did meet in a breakout room to try to come to some resolution. There is not any resolution. Is that correct, Mr. Riddell?
That's true, Judge. There was no resolution.
All right, Mr. Riddell.
Your Honor, I have Mr. Alex Altman here. He just came in. So it's Edward Altman and Alex Altman on the call.
All right, Mr. Alex Altman, could you say your name for the record?
Alex Altman. My apologies, Your Honor.
Can you gentlemen turn your video on?
Hold on. Let me see if I can figure it out. Give me a second. Just press that. You got to press the camera button. Hold on. Here we go. Start. Yeah. Hold on. Hold on. It's saying I got to change my settings. Give me a second, Your Honor.
Okay.
Right.
Yeah, Judge, I'm pretty sure misrepresentation was made to the court because when this was started, we were told that Alex was not present. He was in the hospital. And when we went into the breakout room, I discovered that there were two voices. I asked who the second voice was, and they would not disclose who it was. It was described as a friend who was giving him some advice on what to do. And I suggested to them that, well, it's either Mr. Altman or it's somebody engaging in the unauthorized practice of law. the person was not identified as an attorney. We were told they don't have an attorney. So I just think we need to keep.
Can you still hear us? No.
Forward.
Why not?
Veracity of the things that these people say.
No.
Mr. Riddell, I certainly understand and appreciate your position.
Hello?
As I know you're
That's annoying because he's using. This is going to be another dodge. Is they're going to say, well, you can't enter an order against this guy because he's a different guy when they gave false information. So I understand exactly why the attorney's getting cranked up right now. I would be too.
aware the court does
Hello?
need to make a finding of whether or not there are any triable issues today. So we're going to go through that process, and then I'll make a decision on your motion for the judgment today. Okay.
Very good.
Okay. Hello. Yes. It says please allow Zoom to okay, access. Yes. Okay. Can you hear us, Your Honor?
Yes, we can.
Okay, it's I guess because of the call already started, it's not allowed. I'm trying to access the camera, but it won't start my video. Yes. Unable to access camera. Please allow Zoom to. Okay, Your Honor. Yes, and it was a friend of mine here because I wanted him to listen to what was going on because my husband has a problem with
Mr. Altman. Mr. Altman.
Understanding.
Mr. Altman. Mr. Altman. You're making representations to the court here today regarding this property. Okay.
Okay.
I agree with Mr. Riddell that your initial explanation here was that Alex Altman was.
This is Alex Altman speaking now. This is not Edward.
Okay, well, I don't have the video, so I apologize that I can't determine who's speaking. But there was a representation from Edward Altman that Mr. Alex Altman was in the hospital. And was that a lie?
No, I had a doctor's appointment and I couldn't miss it. It was for my cancer. So yes, I told him I'll be there as soon as possible, and I rushed here.
All right.
But the whole matter, Your Honor,
You can submit.
Oh my God. I don't know what happens in this hearing, but I want them tased now. I don't believe anything that's coming out of their mouths. I don't believe that they can't get the camera working. I don't believe the number of people that are there. I don't believe anything already. We lied about being in the hospital. Plus, now I'm just left with the visual because we're up to 3 people. What I picture is just like the Village people sitting in this hotel room. I'm sorry, that's the visual I'm left with when you don't turn your camera on.
Mr. Altman, you can submit proof of your doctor's appointment this morning.
Yes, I surely will. And I'll also submit the paperwork from when we first initially got there. When we filled it out, we put down husband. It's been crossed out and it says dead. The whole matter of them with this eviction is based on we're homosexual, and the owner does not like that at all. We offered to pay him the money. We called after he said you have to move this.
Sir, after 3 or 4 words, you did not have to announce your homosexuality. Number 1. Number 2, that's going to be pretty hard to prove. That's a pretty convenient thing to say, oh, no, they're just bigots when you haven't paid. I'm not buying it.
Out, we moved it out. It said, oh, we have the money, the back payment or whatever. He was like, no, I don't want the money. I just want y'all gone. We have letters from the former employee, the former employee.
Mr. Altman, when the court talks, you need to hang on, okay? Because I'm not just going to let you go on a half-hour rant here. All right, we're gonna get to the purpose of what you're interrupting me again, Mr. Altman. I don't want to have to just put you on mute. I need you to. This is not just going to be you speaking. I have some questions. I have certain things that the court needs to determine today. Okay, so you're going to respond to me as we move forward here, and you're going to stop talking when the court starts talking. You understand?
Yes, sir.
All right. The offer from Mr. Riddell earlier was to allow an extended amount of time to stay if you paid the rent. So I'm confused on why you wouldn't just take him up on that. This seems to have a resolution here that you can pay the back rent and post the bond of the amount of time that you want to stay. You're saying that you tried to do that. They're saying that they would allow you to do that. So I don't understand what the disagreement is on that point.
Judge, you may have misunderstood what I was saying, and I apologize if you did. What I was saying is that they were going to ask for a trial date, that I think it should be subject to the fact that they pay the amount of motel charges that have accrued to this date, plus post a bond for their continued possession up to that trial date, because they've been living there since the beginning of November, not having paid anything. Now they both say, and they're puzzled by it. Well, why are you demanding we pay now when we tried to pay and the company wouldn't take the money? I've tried to explain to them that that's the required procedure in a termination case, that you can't accept money after the notice of termination because acceptance of money is inconsistent with the notion of termination. So the client was actually doing what I advised the client to do, and that is don't accept any money until we get a determination by the court.
All right.
So but we danced around that argument over and over and over again, Judge.
How much is currently in arrears?
1 second, let me get to my page over here. From the date of the notice of termination, the accrued arrearage is $2,640. From the date of their last payment of any weekly tenancy charge, occupancy charges, the amount due is $3,360. The amounts accrue at the rate of $240 per month.
If what you just said, no, that's $240 a week. That's what we pay.
I'm sorry, Judge, I misspoke.
We have every receipt because your client has been lying to the court on how he runs his business. I have every receipt that we've paid. Even sometimes if we're late, we pay over fees. We just actually read the packet that he made us sign when we first moved in.
Right.
It says,
Mr. Altman, how much do you believe that you owe? How much do you believe that you owe at this moment, Mr. Altman?
About 2,500. I have to look at the last payment we made.
This is the date and time for this hearing, so now is the time to look at it. This is the information that this court needs.
All our receipts that we have is at the place. Your Honor, we've been trying to reach out to a lawyer. We didn't even get a court-appointed lawyer for this matter. That's why we thought we had to find our own lawyer for this.
That's correct. You don't have a right to a court-appointed lawyer, Mr. Altman. There is no constitutional right to an attorney in this type of case. That's why the court gave you an adjournment of, I think, about a month. It was a pretty lengthy adjournment for you to seek out.
I think January 9th or 8th is when we first convened on this case.
Yeah, we have been calling around and reaching out. We both work. It's just we're frustrated because we've never been through this, and we've been very, very, very just trying to make things work with the owner, because he even come up there and call our room, and we spoke. What he's telling his lawyer and he's telling y'all is not the same thing he's telling us. We've never experienced this or got evicted from any place. We've never experienced anything like this.
All right.
So,
what is, Mr. Altman, what are the allegations with regards to the discrimination that you feel like is happening?
Once the owner came back in town and he took control of his property and he found out that we were gay, he immediately started treating us a different type of way. And then a week later, he said, "Oh, y'all have to move because of the clothes y'all have here." We've asked the managers and stuff, could they take out some of the dressers and stuff that's in there, because the room is just cluttered with furniture that doesn't need to be there. So we can fold up and put our clothes up in there. So when they didn't do that,
Mr. Altman, what is the discrimination? You've made allegations about discrimination.
Because he found out that we were gay, and he immediately wanted us to move. Even on the paperwork that we signed, I put down husband. It's scratched out and says dead. This is my husband. This is not my father.
Are you talking about the registration?
Yes, we have paperwork as well as the case that's going
That's
on
in your
between.
handwriting?
It's in
It's in the hotel's handwriting.
it's in a hotel handwriting.
From
It's
the registration page.
for the registration
Right,
page when we saw.
I'm looking at it right now. You're saying that you said you put down husband and it was scratched out and now says dad, but it doesn't. I don't see
Yeah,
anything scratched out. It just says dad. And actually, it
that's
says
my
that under your emergency contact information.
no. It says see on mine. It says relationship dead. I
Yes,
wish I could try to get this
you
camera.
said you put
I,
down husband, but it doesn't look like
yeah.
that you wrote any of that. That looks like something that the hotel wrote, and I don't see it scratched out at all.
The one that I have in my hand is my signature, but it looks copied. But it's my husband's handwriting. It's I don't know how to send you the paperwork that we have, Your Honor, but I thought we was going to come into court.
So if that became known to them, if they knew that you were husband at the time that you were checked in at the guest registration, are you saying that the discrimination took place then since the entire time? I mean, did they find out that you guys were in a relationship at the moment you checked in?
They knew that we were married when we checked in. The manager knew that we was married when we checked in. I don't believe the owner knew.
And so it was.
As soon as the owner came back in town and he started going around to people's rooms and he met us, he made a statement. I said, "No, that's not my dad. That's my husband." And he looked at me. He looked at both of us kind of funny, and then went on about to the next room. And then a few days later, because we was due to pay rent that following Friday, and a couple of days later, we received an eviction in the mail. Like, wait a minute. We went to him and we told him, we said, well, if we're late, we pay whatever is back owed, plus the late fee or whatever. We have you see our payment record. And he was like, okay, no, that's fine.
So, Mr. Altman, the proof so far I've heard with regards to potential discrimination is that the owner came into town and looked at you funny.
No,
Was there
he
anything
found
else?
out. When he made the statement about that's your dad, I said, no, that's my husband. And from that point on, it's been a problem and an issue. The case,
Right. Okay, so that's what I want you to focus on. What are the problems and the issues? You say that, but I don't
okay,
understand what they are. So that's what I need to hear.
since that happened, since he found out that we was like that, we received an eviction letter for saying we wasn't gonna pay, but he filed it before our rent was due, and then on top of that, they start cutting the heat off. People, I don't know who it was been coming in our room while we was gone, and then the previous housekeeper, she knows everything that's going on because she witnessed it and she was aware of it, and she was trying to tell us about all the stuff that was going on there, but I just didn't want to get into.
You're speaking in generalities. I need specifics. The court needs to determine whether or not there's anything to have a trial about, Mr. Allman, and the things that are going on. What are those?
That got me.
Of the managers running the business however they want to, regardless of the owner's feelings on homosexuality, because he told them that he didn't want any gay people on his property.
You heard that from who?
The previous housekeeper, as well as a conversation between the two managers that work there.
What are those people's names?
Give me 1 second, Your Honor.
It should be on the thing. Yeah. This is so frustrating. I can't find it, Your Honor. I actually have it. It's in the room. I don't have. It's in the text. It's in the text message you sent. Here. I'm sorry. Oh. Give me a second, Your Honor. I'm finding the text. I got it on the text. Rhonda. The former housekeeper name is Rhonda Swarskowski, I believe. Swarskowski, I'm not sure if I'm pronouncing her last name right.
And do you have her contact information? Would you be calling her as a witness at the trial?
Yes. Yes, I would.
No. Do you have her contact information?
Yes, I do. I'm bringing it up now.
Judge, so that you know, she's a defendant in another landlord-tenant case that I have before Your Honor. Her first pretrial was also early in January, and she's been adjourned to February 18, I believe.
Another deadbeat scammer squatter.
I'm pulling up the text message. All right. The manager's name is Kenneth Christine. And the other gentleman, the owner's name is Rajan Patel. Mr. Christine is the manager. I don't have the second name for the other individual that works at the hotel.
All right.
Your Honor.
Mr. Riddell, I think we've finally gotten to the point here where the court, it's a very low burden and to make a determination here. And I do think that they've brought forth enough of a comment and argument here where there could potentially be a triable issue and the court can't proceed with your request to enter judgment short of a trial. So we'll set this for an in-person trial date here at the district court, but I am going to grant your request that there be some interim amount of rent paid. The parties agree that there is at least $2,500 due in back rent. So that will be paid forthwith to your client, Mr. Riddell, the $2,500. There's a discrepancy about whether or not there's an additional $860 due and owing at this time. That amount will be paid forthwith to the court's escrow account. And while we are waiting for a trial, the amount of $240 per week will accrue and be paid monthly into this court's escrow account.
Weekly, Judge?
It's a weekly amount. That's correct. So it'll be paid weekly into the court's escrow. So,
Judge, will the order provide for consequences if the deposits are not made?
Yes, a default on that is a default, and we'll move forward. So this needs to be complied with. The parties agree that there's a $2,500 arrearage that should be paid forthwith. Defendant has acknowledged that they have the financial wherewithal to do that. The $860 that's in dispute at this moment will go into the court's escrow account, and then starting from Mr. Riddell, your allegations are that brings the 3,360 brings you all the way current to today's date?
To this week.
To this week. So the next payment of $240 would be due for the week of the 2nd. Is that correct?
Yes, that would be my thought, Judge.
All right. And then the week of the 2nd, typically is that payment due, the Altmans, are you making that payment on the Monday of each week or the Friday of each week? How are you typically making that payment?
We usually pay like Friday. We usually pay Friday, but when we usually pay like a month or 2 months in advance. We've been doing that since we got there.
Okay, well, this is changing for today. This is the court's ruling. We're going to keep it on a weekly thing, and it'll be due on every Friday. So the first $240 payment will be due on the 6th. So forthwith, you need to pay. That means immediately. You need to pay the $2,500. Mr. Riddell, how do you want that paid? That is not in dispute. So where do you want that to go?
Delivered to my office, Judge, so I can verify a receipt.
Okay, so the Altmans, you need to make arrangements to get $2,500 to counsel's office, Mr. Riddell. $860 needs to be paid to the 44th District Court. That'll go into the court's escrow account and be held until this case is decided. And then on the 6th, the next payment is due of $240, and every Friday thereafter, additional $240 are due into this court's escrow account. Do you have any questions about that portion of things, either Altman?
I just want to make sure 240 is due to the court for February the 6th.
Yes, so it's going into our escrow account, so it's held there until the case is decided on where it needs to go. Okay.
Okay. You also said another payment of what was that, 866? But I didn't hear where is it going and what does it do for?
Okay, I'm going to try this again. All right, you ready for this, Mr. Altman? $2,500. You've acknowledged that you have an arrearage of $2,500. That's not in dispute.
Right.
So that is going to Mr. Riddell, and that needs to be paid immediately. Okay.
Today.
Okay.
Today. It needs to be paid today. There is, Mr. Riddell has argued that there's actually $3,360 that are in arrearage. So that extra amount is, in this court's view, in dispute. So that $860 in dispute needs to come to the court to be held in escrow until the case is decided. Do you understand that?
Okay.
All right. And then that needs to be paid also immediately, forthwith. And then the next payment of $240 is due to the court on the 6th and every Friday thereafter until the case is decided.
Your Honor, may I say something? This is Alex speaking. I wish your camera would work. The 860, I can pay that this Friday to the court, the 25, because for some odd reason the heat has not been working in the place over there, so we haven't been there. We haven't been there at all. We go there to pick up to get our clothes and get our stuff.
Oh, bullshit.
But we've had to stay somewhere else because the heat has not been working, and for some odd reason the power be going in and out. It's just like they're trying to make it uncomfortable. But if we could work something out with the lawyer, by what, next week?
At least 2 weeks.
At least in 2 weeks we could give him by next week, we could give him the full 2,500. We could give that to him. But this Friday, we could put the 860 in the court escrow account. We could pay that this Friday. And then in 2 weeks, when we both get paid, we can give him the full 2,500. But we've had to seek other places because they're making it unlivable for us to be there, so we have not been there.
Judge, if they've moved out, if that's what he's saying, then
I have not moved out. We have not been there because they've been making it uncomfortable. We go there if we have to, and we sleep there, but it's been uncomfortable. These past couple of weeks have been cold. That room is ice cold. If you walk in and out, it's like a freezer. But everybody else heat work.
The court's made its ruling with regards to the payment schedule. All right. These are issues that we can discuss at trial, but you'll need to come up with the $2,500 that you agree that you owe by the end of the day.
Yeah.
You'll need to pay the $860. I'll give you until Friday to get the $860 in the court's escrow, but that $2,500 needs to be paid to Mr. Riddell today.
my address on the pleadings.
On the pleading. $860 into the escrow, and then $240 a week or every week.
A week. Every week. There. Well, he
Riddell is excellent, and he has been this entire hearing. And by that I mean he only says what needs to be said and nothing more, and then just lets everything else happen. He's a consummate pro, and it's a good illustration of how this stuff works if you're represented, and it never does if you aren't, as we've seen so many times.
Well, will he take a post-dated check?
No.
Oh no!
Here his answer. That's the order of the court.
That's a hard no, and he's right.
I'm gonna see if I can move some things around.
All right. Now let's set a trial date.
Happen. Can it be? But can both payments be this Friday then? That give us a little bit more time to try to figure something out.
It's 10 o'clock in the morning. You'll have to figure this. This is the amount that you agree you owe. Okay. So this is what needs to be paid. The
love it.
Trial date, Mr. Riddell.
Sooner the better, as far as I'm concerned, Judge. I just need to make sure it's not within the next 5 days or 7 days, because Raj Patel is the key name in all of this, and he's been out of the country over the holidays, and he's going to be back at the beginning of the month. Once I have Raj back, I'm ready to go. I will be before you on another landlord-tenant matter on February 18.
18?
That is crazy.
Mr. Altman, are you any objection to the trial date of February 18th?
Can we get an additional week on that, Your Honor?
Actually, my thought was
Mr. Patel is out of the country,
but he'll be back. And my thought was actually the week before. So Mr. Riddell's offered an additional week beyond what the court was. I was looking at the week of the 9th. So I think he's giving you more than enough time there. This will be the 18th in the morning. It's going to be in person at the district court. Both parties need to have all of their witnesses here and available. Any documentary evidence here and available. This will be the trial date, and any kind of documentary evidence that you intend to produce to the court, you need to have additional copies to show the opposing party so that they have a chance to look that over. Anything else for this morning, Mr. Riddell?
No, Your Honor.
The Altmans, anything else this morning?
Is it possible you could point us in the right direction of a civil rights attorney? Because we seem to can't locate or find one.
Well, when you watched the video last week, there was the Lakeshore Legal. One second. The State Bar of Michigan has a referral service, and that phone number is 1-800
Yes, Your Honor.
968 0738.
They're going to end up with Meg somehow.
Thank you, Your Honor.
All right.
Your Honor?
Yes.
I'm sorry, I did have one other thing.
Please.
I want everybody to recognize that my office closes at 5 p.m. I may not be here at 5 p.m., but if somebody comes to make a delivery up to 5 p.m., somebody will be here to receive it.
All right. The Altmans, you understand that? 5 p.m. today, the $2,500, $860 Friday to the court, and $240 every week thereafter.
Yes. Can I ask one question? Why do I understand we acknowledge that we owe the 25, but why is it being stated that we have to pay it today? We say we know what we owe, and we do have the means of payment, but we never told him that we have the money like right now to pay.
Well, you haven't been paying. Your notice to me earlier was that you attempted to pay and it was refused, and we've gotten to the bottom of why that was.
And when
the landlord.
So your BS caught up with you. Yeah, you don't have the money. You're not going to pay it today, and you're going to get kicked out. which is the right result. The attorney knows it. The judge suspects it. And I suspect it as well.
There's issues about whether or not you're being evicted inappropriately, but that doesn't mean that the landlord has to provide you a space rent free. And so
Correct.
that's why that the court made that determination. Okay.
Okay, Your Honor. I'm
Right.
I'm about to get on it right now. Thank you for your time, your understanding.
Take care, everybody.
Judge, will you be issuing an order on this? Or is this just a minute order on the file?
What do you have everything consistent with what I ordered written down there, Mr. Riddell? If you submit an order, I'll sign it today.
Okay. Thank you very much, Judge.
All right. Take care.
Take care.
Bye-bye.
He's a pro right to the end because he anticipates that there will be a subsequent hearing and there will be more BS. So he wants it. He wants everything that happened in this hearing to be on the order. Whatever. It's 5 minutes of focus. You bang out an order and then it will all be on there. And the judge will sign it because he won't say things that the judge didn't order. The judge is confident of that. That's the order that will enter, and then this nonsense will be over. I was scared for a while there, but the judge came through. When he gave the continuance, I'm like, oh no, but then he's like, all right, but pay. Which is exactly what the attorney suggested, which is exactly what should happen. That was a lot of fun. And Zach sent that to me and he warned me about the post-dated check, but then I forgot about it. And when it happened, that just floored me. Good times. Thanks for coming out. I appreciate it. I'll see y'all soon.